Welcome to Bankruptcy Myths and Lies. Today's myth is that Congress eliminated bankruptcy protection in 2005. This is a common myth, but it is simply not true. Creditors want you to believe this is the case because they don't want you to know that you have options other than what they want you to do. To make matters worse, in 2005, there's a lot of fear-based advertising by bankruptcy attorneys right before the law went into effect, claiming that the new law would eliminate the right to file bankruptcy. All of this led to the myth that bankruptcy protection was no longer available to people who needed it. What is true is that the credit industry did their best to eliminate as much of the rights and protections for consumers and small businesses as they could. Fortunately, the success was not complete. To understand what happened, you need to know a few facts. First, prior to 2005, the bankruptcy laws worked the way they should. Good people who needed help got the bankruptcy protection that they needed. Bad people who were committing fraud and flakes who did not need bankruptcy help were denied a discharge of their debts. Yes, a few bad people who lied or hid assets and did not deserve bankruptcy protection ended up getting their debts discharged. However, these were relatively few, and if found out, many had their discharges revoked. The credit industry did not like the fact that the bankruptcy laws worked. So they thought, gee, what could us creditors do to break the system? Then, like any villain with lots of money would do, they said, gee, we can rewrite the bankruptcy laws in our favor, which is exactly what they did. They paid bribes, political contributions to get their law passed. Then they called the law the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005. The law was supposedly passed to protect society from bad people who could pay their creditors. Of course, it was the proverbial wolf in sheep's clothing. If it were labeled using truth in advertising, it should have been called the Bankruptcy Abuse Punishing Consumers and Creditors Protection Act of 2005. Well, it did make bankruptcy much more complex and more expensive. Most people who need to file still can if they get good representation. The bankruptcy law was designed by creditors to make it risky for people with above median income or with assets that are worth more than could be protected in bankruptcy to file without the advice and skill of an attorney. After all, if something was not protected, guess who gets the money? Many people not represented by a good bankruptcy lawyer do lose cars, bank accounts, tax refunds, and even in some cases their homes. I know because I regularly get people in who are having things taken in bankruptcy because of poor or non-existent representation. In some cases, it is too late for me to help them. Sometimes you can't unring the bell, as the saying goes. They risk thousands of dollars, some hundreds of thousands of dollars, just to save the cost of hiring a bankruptcy lawyer, and lost much more than a bankruptcy attorney would have ever cost to begin with. Let's put it this way. Would you want to use a veterinarian's assistant to do brain surgery on you because they can read a book on the subject and will charge you less money than the brain surgeon? Think about it. Would you do that? There are many people out there, including paralegals and, unfortunately, some attorneys, that think bankruptcy is about filling out papers. It is not. It is about knowing where the landmines are. It's about timing, exemption planning, income planning, tax issues, why you may want to change banks, understanding how the judges interpret the means test, and so much more. Bankruptcy is only a tool. Some think that it is the only one. In reality, it is only one among many to help people. The real work for a bankruptcy attorney is in pre-bankruptcy planning. That is where the quality of the bankruptcy attorney makes all the difference in the result obtained. If you think you need good advice about your options in dealing with bankruptcy or financial problems, Don't make seeing a bankruptcy attorney your last resort. That is true even if you do not intend to file bankruptcy, or if filing bankruptcy may be a choice of last resort for you. You need to know all of your rights and options before you start making financial decisions that could come back to haunt you. Isn't it wise to get as much knowledge as possible? I'm Gary Fraley, a State Bar Certified Bankruptcy Law Specialist. I have over 35 years experience in bankruptcy law and well over 10,000 cases. Give me a call at 916-485-5444 to schedule a free attorney consultation. Remember the saying, knowledge is power? Isn't it time you got your power back?